Has been reserved in the country's second highest court regarding whether gravely ill patients should be afforded the right to choose when to end their lives. Advocate HB Marais earlier addressed the Supreme Court of Appeal in Bloemfontein on behalf of the family of Robin Stransham-Ford in the euthanasia case. A state in the euthanasia appeal case has argued in the Supreme Court of Appeal in Bloemfontein that the right to dignity does not entitle gravely ill to assisted suicide by medical doctors.
The Justice and Health Ministers have forged ties with the Health Professions Council of South Africa in challenging the ruling by the High Court in Pretoria that a medical doctor can help a terminally ill patient to commit suicide without facing sanctions. In May 2015, Judge Hans Fabricius gave 65-year-old Cape Town advocate Robin Stransham-Ford permission to a medical doctor to assist him to end his life. Stransham-Ford, who suffered from advanced prostate cancer, passed away before he could hear the landmark ruling.
Legal analyst Brenda Wardle joins us via Skype for a look into this matter. Brenda, good evening and thank you so much for joining us. Now, does the argument by the Department of Justice that the 2015 judgment could set precedents to hold water?
Well, good evening, Lulu, and good evening to all the viewers at home. For me, it's quite a tricky one, and I was critical of the judgment of Judge Fabricius, who actually issued the ruling that they've now gone to the Supreme Court of Appeal on. Because he granted the order and issued the judgment an hour after Stransham-Ford had actually passed away. Now, if the applicant has passed away, and I was surprised that, neither the NPA nor the Department of Justice and nor the Health Professions Council actually raised that fact, because even though assisted suicide, euthanasia, etc., is very, it's a very important topic all across the world, I don't think that this case ought to have gone the route that it basically did. So in terms of our doctrine of precedent, yes, that decision does actually bind courts under that court and all other tribunals, etc. Sorry, so it is a precedent-setting one, and also perhaps a dangerous precedent-setting one.
Now, the right to life is enshrined in the Constitution. Is
Yes.
assisted suicide not contravening this very particular piece of law?
Well, if you could have regard to the judgment by Judge Fabricius, he raises some, I'm not sure whether to call them controversial, etc. But as you correctly point out, Section 11 of the Constitution enshrines the right to life. And we had the state versus Makwanyane, which was the death penalty case, where it was actually ruled that everyone has the right to life. Well, the judge, rather, in his judgment, relies on abortion, that abortion is permitted, and I'm not sure whether legally that is quite the correct thing to basically say, because the Constitutional Court judgment on abortion was actually clear. But he relies on that in his judgment, and then he goes further and says that the world over, people are killed by weapons of mass destruction. In South Africa, people die in car accidents, people die from HIV and AIDS, from diseases such as malnutrition, etc. And those are the parallels which he uses, which for me was very, very problematic. And then he almost stresses the point that Stransham-Ford was an educated person, an advocate of the High Court. At some stage, he was a tax consultant and in London, etc. And therefore, because he is educated and knowledgeable, he ought to have been given that right, and in fact he did grant him that right posthumously for him to either terminate his own life through suicide or for a medical practitioner to basically do that. Because Judge Fabricius argues in that judgment that it's the quality of the life which gives effect to the right to human dignity, amongst others, not just the right to life per se.
Now, the Health Professionals Council has argued euthanasia can be abused in South Africa because of the imbalance in power of doctor-patient relationships. Is this correct?
Well, there are those concerns. If one has regard to the Law Reform Commission report, which obviously hasn't been legislated, it hasn't become even a bill before Parliament yet. If you look at those recommendations, there are certain safeguards which actually would have to be in place for people, because some people are arguing self-autonomy. It is my life, I make all other decisions, and therefore why am I not allowed to make these decisions? And it's always been problematic because, for example, during my master's in medical law, this was one of the subjects that we dealt with. But even after I had written and passed my exams, I still don't know, because the arguments are so complex and are so detailed that it's very, very difficult. It would have to be in a structured and controlled environment, and I don't know how they would really go about it.
Brenda, we have to leave it there for now. Thank you so much for joining us.
It's a pleasure. Thank you.
That was our legal analyst, Brenda Wardle, joining us via Skype.